The Civil Rights Act of 1964 changed American discrimination law forever. It prohibits employers from discriminating on the basis of race, color, religion, sex, or national origin. But does it protect homosexual and transgender individuals? The United States Supreme Court considered that question in Bostock v. Clayton County. Gerald Bostock worked for 10 years as a child welfare advocate for Clayton County, Georgia. Shortly after Bostock started playing in a gay softball league, the county fired him for conduct unbecoming a county employee. Bostock sued in federal court for sex discrimination under Title VII of the 1964 Civil Rights Act. The district court dismissed his claim, and the 11th Circuit affirmed, ruling that Title VII didn't prohibit discharge for homosexuality. The Supreme Court granted Bostock's cert petition and joined his case with that of Donald Zarda, a skydiving instructor fired a few days after mentioning he was gay, and Amy Stevens, a transgender woman who'd worked for years as a man for a Michigan funeral home, but was fired after informing her employer that she intended to live and work as a woman. Both the Second Circuit in Zarda's case and the Sixth Circuit in Stevens's case ruled that Title VII did prohibit employers from discharging employees for homosexuality or transsexuality. The court considered whether Title VII protects homosexual and transgender individuals from workplace discrimination. The court answered yes, that Title VII protects homosexual and transgender individuals from workplace discrimination. Justice Gorsuch, writing for a six-justice majority, explained that, in pertinent part, Title VII of the 1964 Civil Rights Act makes it unlawful to discriminate against any job applicant or employee, quote, because of such individuals' sex, unquote. Gorsuch explained that because of sex translates to but-for causation. But-for causation is established whenever a particular outcome wouldn't have happened but for the purported cause. So a Title VII defendant can't avoid liability by citing some other factor that contributed to the challenged decision. If a plaintiff's sex was one but-for cause of that decision, Title VII is triggered. When an employer fires an employee because the employee is homosexual or transgender, two causal factors are in play, both the employee's sex and either the sex to which the employee is attracted or with which the employee identifies. But the employee's sex is unavoidably part of the employer's decision, and that's what Title VII specifically prohibits. Gorsuch offered two examples. He postulated an employer with two employees, a man and a woman, both of whom are attracted to men, and both of whom are competent employees. If the employer fires the man solely because he's attracted to men, a trait the employer accepts in his female employee, the employer is discriminating solely on the basis of the employee's sex. Likewise, if an employer fires a transgender person who was identified as a male at birth but now identifies as a female, while retaining a female employee who has identified as female since birth, the employer is firing the transgender individual for now identifying as female, a trait the employer accepts in the other employee. Again, the only difference is the sex to which the employee was first assigned. In response to dissenters, Gorsuch acknowledged that Title VII might possibly reach farther than its drafters in 1964 anticipated. But when applied to these cases, the statute's plain language can brook no other resolution. The court concluded that the plaintiffs in all three cases properly accused their employers of violating Title VII. The court reversed the 11th Circuit in Bostock's case and affirmed the Second and Sixth Circuits in Zarda and Stevens's cases. Justice Alito dissented, arguing that Congress has for many years considered but failed to pass bills to add sexual orientation or gender identity to Title VII's list of protected categories. That Congress has considered adding these categories means that Congress doesn't believe that Title VII currently protects them. By ruling that Title VII does protect them, the court is legislating from the bench. Justice Kavanaugh also dissented, arguing that the question of whether to add sexual orientation and gender identity to Title VII rests with Congress and the President, not the court. Bostock v. Clayton County will expand the reach of Title VII to protect many more individuals from workplace discrimination.